Dear students, welcome to the Industrial Property Law course. So that would be HOE 6065. There's been a bit of a change, so I'll be handling this course in this term. Unfortunately, the previous person who was dealing with this, I think, she was senior lecturer Marie Min. She passed away in December on Christmas Day, and so, unfortunately, there's been this sort of a situation. So, I'll be dealing with this course in this term. As I understand, also there will be some changes in the coming autumn term in the in the new year, academic year. So my advice to you would be, let's just get this over and done with, and then, I don't know what happens in the next term. All right. This particular course, industrial property law, is a bit similar to something that I taught in the previous term, intellectual property law, if you may recollect. The only thing here is, this particular course that we are talking about in this term, the industrial property law course, is a purely legal course, and it has a lot of legal elements to it. I mean, it's almost entirely 100% law oriented. Now, that is a bit different from what we had in the previous term with intellectual property law, because if you may recollect, in that class there were almost 75 students. More than half the class were from the engineering faculty, and so I had to really dumb it down and keep it very simple. So we had notes like the UK IP booklet. That's IP law for dummies. Then we had the UK trademark booklet. That's the trademark law for dummies, and so on and so forth. Also, in that particular course, the focus was more on some of the science aspects. So patents really played a very important role there, but more from the drafting point of view and things like that. But that was last term, all right, in the previous term. So today, and in this particular term, this particular course, industrial property law, once again HOE 6065, is more about how the various directives and regulations play a role, and there are a lot of case laws as well that have to be dealt with. Now, just like in the previous terms, and in 2020, we will be having this class purely online. I don't think it's reasonable or expectable to have a class in the classroom. Unfortunate though that is, that's how things will be for the near future. So, we don't have much of a choice. Just like in previous terms, what I'll be doing is I'll be recording my video lectures on YouTube and then putting up the links in Moodle. Yes, it is possible to also do some lectures via Microsoft Teams or some other such programs, and we'll look into that as well. I will put up announcements regularly in this regard, and then we can take things from there. And then, of course, if you have any questions or queries, please feel free to ask me on via my email address or via Moodle messages. Or we also have a course participants forum, so you can even discuss things over there in a free manner, and then everybody can be a part of the discussions if required. So, I have had to make some changes in the Moodle course, which I inherited from Marimin. Of course, some things had to go and then some things stayed. So I'm still in the process of recreating this Moodle course. And if you were to go online, you would already see that trademark law is more or less up, and it has all the necessary aspects to it. There are trademark case laws, so pay attention to those. Quite a few of them, many of them. And as law students, you would be expected to know these in real good detail. One document I would like you to focus on as well at this early stage would be the extended syllabus that you see for this particular course in Moodle. And it sort of answers a lot of questions, hopefully, that you may have. Again, the emphasis is on legal analysis. So I understand that there may be some students, Erasmus students, etc., who don't have a law background. Well, I'm sure you'll cope very well. After all, law is common sense. Yes. The focus will be again, well, as mentioned over here, on um, trademarks, patents, designs, geographical indications, and trade secrets. So we'll be looking at the various directives that play a role over here, as well as the regulations, the convention, for example, and things like that. We don't have copyright um, in this package because copyright is not industrial property. How do you say it? Well, we have intellectual property law, and that comprises of industrial property, which by its very name, as you can imagine, has industrial commercial implications. And then there is copyright law, which has its own aura to it, and which is different from industrial property. So we'll be looking at the various the various subjects that come up over here. Of course, study literature. Well, we have all the material in Moodle, but if you are interested in reading something more, we have some textbooks from Cornish. That's good enough. Well, it's published in the UK, but so far the UK is still, the laws of the United Kingdom as far as IP are concerned are still compliant entirely with the European Union. I don't know what may happen in the future. Hopefully not much. Then there are some other books as well on this subject because of the global nature of IP laws and the fact that they're all more or less interlinked and interconnected. So thanks to the United Nations, WIPO, World Intellectual Property Organization, the TRIPS agreement, trade-related aspects of intellectual property rights, things like that. So more or less all the laws are quite synchronized. Because most of the class students tend to be from Finland and then Estonia, and then of course we have others. Usually there used to be a big group from Germany and from France. Well, not very big, but substantial, and many other Erasmus students. So we are still seeing how that develops and forms up. So it doesn't make sense to focus on a national law as such. So we'll be talking more in terms of the European Union wide aspect of things. And yes, some maybe comparisons with something that is comparable. So European Union vis-a-vis the United States, for example. IP laws have been in a state of flux, and here IP, I mean industrial property. And because of the digital revolution and all this emphasis on 4G and 5G and the various aspects of the internet, there have been a lot of new developments that we'll try to keep abreast of as well. Again, purely from a law perspective. All right. This course, once again, it's for lawyers, for law students, and we'll be looking at everything purely from a legal perspective. There will be, as usual, an exam. So that exam is 60 marks, written exam, open book, obviously, because we're doing everything online. And also there will be essay question homeworks, so 2 essay homeworks, 20 marks each. So as usual, 60 marks for the exam, 40 marks for the homework, and well, that should take care of everything. Those of you who are aware of my teaching style, well, everything is on Moodle, everything is transparent, it's the same rules for all the students, no special exceptions unless you have a medical certificate. And so we try to keep everything in order. One very important element of law studies is that you should learn to understand and appreciate the importance of guidelines and deadlines related to your time limits. Limitation is a very important aspect of law, time limitation especially. And you can't really have any excuse for uploading homework assignments late, just as you can't have any excuse for uploading any court documents in a court of law late. So you have to be careful about this. As usual, all my homework assignments have 30-day time frame. 30 days is long enough. If you can't do it in 30 days, I don't think you'll ever do it. All right. So please don't try to wait till the last minute. I know some people have this habit of, waiting till the last 4 seconds, but this is not one of your eBay auction sites where, you have to press your button at the microsecond before the deadline. This is a homework assignment. Just upload it on time. Just be normal and do things the normal way, and you get your grade. And then, if you do it well, you get a 5. Not everybody gets a 5, but the criteria is not super high. You just follow the guidelines, study what's required from you. Of course, because this is going to be an online exam, the emphasis will now be a bit more creative on, case studies and examples which you then have to answer about by thinking about them. So you can't really Google search anything. But of course, for the exam, you just need to know what is in the notes, where to find it. And if you have read it a couple of times, there is an open book exam, and you have 2 hours to answer the questions. There's always a bit of a twist in them, but that's the fun part, right? So it's all over here, and all the requirements that would be expected from you are all laid down over here. So the first lecture, of course, would be about introduction and general definitions. Then we talk about trademarks law. As you can see, there are 4 or 5 lecture notes in this regard. So we'll spend a lot of time on this. Then patent law, again, from a purely legal perspective. Then designs law, geographical indications, and we also look at a bit of trade secrets, and that should sort of wrap things up very well. So how will it go? Well, if you look in your Moodle course page, there are all these lecture notes. There are also some accompanying documents. There's also a folder with trademark case laws. So here's how it goes. I give a little presentation, 35-40 minutes. It's a YouTube lecture, and you also have some supporting documents and some lecture notes to go through. So I'll be doing this every week before the appointed time. I'll put up the lecture, the video lecture, and the instructions. And then on this particular time, on a Thursday between 10 and 11:30, you can sit in your bed in your pajamas and listen to the lecture and do whatever is expected of yourself to do. And of course, if 10 is too early for you, you're not a morning bird, well, you can always watch the lecture later on. In the past, I've had some visiting guest lecturers from foreign countries, and I would always drag in a few willingly or unwillingly. So we have had some Germans who have been very active, and then also some Americans and then others in the past. Well, I don't think that's going to be likely this term. So well, it's just you and me. Okay, so we try to make the most of it. Again, just to emphasize, because this is a law course, and as a practicing lawyer, I don't believe in just a theoretical bookish knowledge. So you need to also have a way of smart thinking about about how these things work out in real life. So we'll be talking a lot about these aspects. So for example, when you talk about assignment of a trademark, you need to keep in mind, for example, the taxation implications. So you can't really be a good trademark attorney if you don't know tax law, because tax can have a huge implication with regard to how the whole commercial sense plays out. So just as an example, those of you who are aware, Stockman, the company, so well, they have this property in Tallinn and in Helsinki, of course. And now what they have done is, because of financial problems and because of the pandemic and all these economic issues, they have decided to sell the house, the building, and now take it back on rent. So from an owner, they have become a lessee, a tenant. Now it will be also interesting to see how they play with, for example, their trademark. Well, maybe they would sell their trademark to some company. Companies are private entities, and then of course, I could set up a company. I could be the 100% shareholder of that company, and still, it's not my company. I'm just a shareholder in the company. I'm not the owner of the company. I'm just 100% shareholder of the company. I may be the director of the company, I may be the employee of the company, I may be the janitor of the company. um, Whatever, company is a separate legal entity. So of course, let's presume that the Stockman company spins off and creates a small side company, a daughter company or sister company, whatever you call it, and sells all its trademarks to this daughter company, and now leases out these, gets on a license these trademarks to use them for the main business. So you can do a lot of these crazy things. Now, why would you do that? Well, tax can be quite a big issue, and of course, you save a lot on taxation by commercializing your IPR in a smart way. And so, of course, when we talk about assignment or the treatment of IP in that context, you always have to keep in mind taxation laws, the duties that are imposed upon you by the state, and then how you can have a sort of you know a sort of a distance between yourself and the other company, and how you can use your IP in a smart way. So you don't work hard, you work smart. So of course, this will also cover other areas. So there will always be a bit of an overlap when we look at trademark law or copyright, or sorry, patent law or design law, because we'll be looking at different features over here. So for example, you can't really deal with commercialization of trademarks or patents or any other forms of industrial property without having a knowledge of the law of contracts, or as you call it, the law of obligations. Then there's also the civil procedure code that you have to be careful about, because it would outline the various requirements for an infringement suit. So these procedures are important. Then again, there may be a criminal law element, because remember, IP, industrial property, has both civil and criminal law implications. So again, to know these things, you would have to have a basic knowledge about the various civil law and criminal law procedures. Now, these parts of the law are not entirely harmonized throughout the European Union. So, of course, what that means is you have the directive or the regulation, which is implemented also in national law of the member states. And then the implementation aspect can sometimes be controlled to a certain extent and sometimes not. So there are a lot of interesting issues that come up when you look at things legally. For example, one interesting issue was under the trademarks regulation. Now remember, there is a directive and a regulation, but we'll talk about the directive more in the course, because the trademarks directive is what you see in, for example, Estonian trademark law or Finnish trademark law, German trademark law, etc. But then there's also a regulation which deals with European Union trademarks, and this would be very fascinating. But now with Brexit, you have some very interesting questions that come up. What are the rights of UK trademarks, or trademarks that belong to UK companies, which used to be earlier European Union wide recognized as EU trademarks, but which are no longer as such. And then so a lot of these things keep on happening all the time. So it's very fascinating to see how implications arise. Already, people are talking about how they have purchased something from Europe, from the European Union, or from the UK on Amazon or eBay, and how the tax implications are beginning to kick in. So if it's something less than 180 something pounds, then you already have to pay 20% VAT, and vice versa. And some of these issues are arising because the UK is not in the VAT regime anymore, so value added tax. So the UK charges separately, and because of all these extra paperwork issues and formalities, the retailers are charging separately and things like that. So you also will see a lot of this from a taxation point of view in the context of industrial property. And it's also very fascinating to see how, if you are in the European Union, there are different rules. But if you're outside the EU, then you can have serious problems when you're sending your products into the EU. So we'll talk a bit about all of these things. and that would of course cover trademarks. There are also some aspects like maybe I'll talk about assignment, for example, with legal documentation. There's also a lot of emphasis on issues dealing with how you have franchise agreements and all sorts of things. So we'll talk about all of these with more detail and more focus on the legal aspects. So there may be a bit of an overlap with the previous terms lectures, intellectual property law. But remember, I mean, that was very superficial, very basic in a non-law fashion, whereas this is more legal. All right. So here you are expected to know what is Article 5 or what are the implications of a particular case law and things like that. Some of the case laws are, a bit older because old is gold. But I've also added two new case laws this year. So we keep on expanding the particular repertoire that we have, or the folder that we have of case laws. Again, of interest for some of you would be the historical aspect. As lawyers, the biggest problem that we have is uncertainty. Yeah, that's the worst thing. You spend 5 years, 10 years focusing on a directive or a law, and now they change it and some new elements are brought in. So this happened with the trademark law, and the directive has been recently introduced about 2 years ago or something, and it has had a lot of implications in certain areas. So we'll look at these, for example, as well. Then, well, it's not up yet, but I'll be putting up patent law. I'll be putting up some lecture notes this time, not the simple stuff anymore. Of course, there's the European Patent Convention. It is interesting because of two aspects. Number one is, well, not only do you have a patent convention, the European Patent Convention, which applies to non-EU member states as well, but you also have some new regulations that have been introduced which would deal with only European Union specific member states. So you have a dual system in place now, and this is of course a transition zone. Again, very interesting because you see things in a different perspective. There is of course the member state and the national law, Estonian law or Finnish law or whatever, and you would think that is good enough. Then you have an EU perspective just in the European Union, and there have been unfortunately some problems with the Spanish and some other countries. So there are some political issues with the European Union patent regime that they plan to introduce. I think just last month the German parliament gave the go-ahead signal. Everything would have gone on, but because of Brexit, things have gotten a bit more delayed. So we'll talk about that as well. And then of course there is a more regional regime like the European Patent Convention, which covers not only EU member states but also countries that are outside the EU, Turkey for example. And of course there are some other implications as well because you have so many countries, Morocco, Egypt, Jordan, Algeria, which are not European Union member states by any figment of imagination, but which have incorporated European Patent Convention rules and administrative procedures. So it's interesting to see how this plays out. Of course, when we talk about all of these things, we cannot forget the US perspective. So there have been a lot of very interesting theses on these topics in the last couple of years that I have supervised. So I'll try to put up some of these as well, just to give you an insight about how these things work out. In fact, one very interesting thesis, which got a very good grade, a 5, excellent grade actually, deals with compulsory licensing under the patent law regime. And when the students started to write it, coronavirus was just a joke. That was already last year in spring, and suddenly this thesis, even the thesis defense committee members ended up saying that the defense, I think, was middle of January this year. And the thesis defense committee members were like, wow, who chooses a thesis which is so topical? And it's so shocking because, it's just something that is so applicable right now. And we are seeing this a lot. especially if you may have been reading the news. And as budding lawyers, I would expect you to read a lot, not just law books, but also news and stuff like that, because you come across a lot of amazing stuff. So, if you may recollect, Pfizer and AstraZeneca have been having some problems with supplying the vaccine for coronavirus, for COVID. And so now the European Union is already talking in terms of imposing export obligations or limitations. And of course, all of this is very interesting because soon the talk may start about compulsory licensing and things like that. And it's not because Pfizer or Oxford, AstraZeneca's vaccines are too expensive, but rather because they're not able to keep up with production. I mean, they have bottlenecks. And so this is where compulsory licensing comes in. And the law would allow such provisions because, of course, coronavirus is a very dangerous phenomenon. And then there are some who laugh at it, but that's because you are young, and you can afford to laugh at it. But it's also had a lot of impact on many of the older people. Now remember, in some countries like Germany, we're talking about more than 50% of the population being 60 plus years old. That's the same in many Scandinavian countries, Nordic countries, Baltic countries. So it's not people like you or hopefully me who will get affected, but a lot of the older people are at serious risk over here. And so, of course, all of this creates this perfect storm. And then again, we are lawyers, so we look at this from a purely legal perspective. What are the provisions under industrial property laws or regimes which could help to solve these issues? So, in the good times, you don't notice many of these problem areas, but when it's the bad times or rough times, then suddenly a lot of interest arises in what the law has in place, and you'll be surprised with what the law allows. I mean, you could actually strip away the property rights from the owner. And in this case, of course, it's industrial property, it's intangible. Value is something that is not really obvious straight away. And so, of course, there are a lot of pros and cons to how IP is dealt with, industrial property especially. Then we look at designs law. Designs law has a bit of this overlap with copyright law, but this is again industrial law. So we look at some of these aspects, geographical indications. Again, there's the European Union directives and regulations on this. So we look at some of these areas, if nothing else, just to appreciate the fact that Scotch whiskey comes from Scotland, cognac comes from France, and things like that. In fact, it's very interesting because one of my students wrote a bachelor thesis on geographical indications with an emphasis on Finland. And well, she didn't even find much material on it initially. So I told her, well, go and ask the Finnish authorities. I mean, there's a home ministry or the Ministry of Commerce or Industries or whatever. And then she actually managed to find somebody, and they gave her a 200-page document outlining Finland's views on geographical indications. As you can imagine, Finland is not really the sort of place where you have a lot of geographical indications. I think there were 10 or 15 at that point of time, which is still quite a lot. But of course, compare that with Italy or Greece or France, where they go mad about what type of animal's milk should be in what type of cheese. I mean, the Italians and the Greeks go really crazy about that. And then you have the Greek yogurt, Turkish yogurt, and these are just a tip of the iceberg. But it was interesting to see how the Finnish ministry already had some very important guidelines and research on this subject, which nobody in Finland knew about because nobody cares about geographical indications in Finland. So again, interesting to see how these things play a role. Then of course you have trade secrets in the end. If you have nothing else in life, then you have a trade secret. That was the original view. Of course, things have changed a lot over a period of time now, and so there have been a rash of new regulations in the US and in the EU. Now, well, unfortunately, we don't have copyright law in the industrial property, subject as such. because a lot of things are happening in copyright law which hadn't happened in the last 20-30 years. So for a very long time you've had trademark law developing and reaching the zenith, and nothing more can go or happen anymore. Patent law is up there. Of course, fourth industrial revolution patents are taking over everywhere. Artificial intelligence is a new area, and of course there are a lot of problems because the European Patent Office does not recognize artificial intelligence, nor does the US Patent Office. What I'm trying to say is inventions invented by artificial intelligence. So again, there's a bit of a log jam here. But copyright law has seen some crazy things happening now. It's all to do with the digital single market in the European Union. And then, of course, you saw a bit of things with GDPR, and that was how to control data and how to impose obligations. Now, that affected Google, for example. Now, the next rash of directives are focused more or towards social media giants and these OTT platforms. So you have YouTube, you have Netflix, and OTTs over the top. So that's Netflix streaming, and a lot of things are happening here because a lot of user created content is being uploaded. Just like this lecture that I will be creating now, then I will upload it on YouTube. Why? Because on my YouTube channel it's possible to watch this on high definition HDTV, and that's always nice. I think I look more better on HD than the usual 240 or whatever that is. Of course, this is user generated content, but in this maybe I may upload something which is not my creation but rather something from somebody else. And what is the liability of the social media giant like YouTube or Facebook? Well, usually it's not much. So there have been some ways to deal with this, but that's just the tip of the iceberg. Yeah, the GDPR and now this CDSM copyright directive in the digital single market are just the tip of the iceberg, because the next holy grail will be taxation of social media giants. Already the European Union has been talking about it, but Australia has actually enacted this. In the coming years, this will also be uploaded by many other countries. And once that happens, you really see how Google's business formula starts coming down a bit. And of course, you see a lot of this happening in the stream of copyright law. But yeah, copyright is not what we'll be dealing with in much detail over here. I may refer to it sometimes just to sort of show what are the implications for the industrial property law regimes. All right, so we'll have a bit of a mix and match over here. But again, purely law, I try to keep it as less boring as possible with more examples and things like that. But yeah, I mean, the case laws and everything are very fascinating all by themselves. Now, let's see how this goes, and I'm very sure that we can get through with this term, and I really hope to be able to see you all in the classroom. It's not the same online like this, because I've sort of become an energy vampire, and I feel that when I'm in the classroom with younger people like yourselves, then of course I sort of absorb in a bit of your energy levels as well. So, well, anyways, we could try MS Teams, but depends again on the number of people in the classroom. One issue has been that there's always this request that, oh, I can't come for the lecture on MS Teams or on a Zoom meeting, but why don't you record it and upload the recording? And that sort of takes away the whole effect over here. So, well, yes, it's unfortunate that this is becoming a monologue and it's just me talking and you listening to me while eating your breakfast cereal or a donut or something in your pajamas. But well, this is how it is. But of course, we could try to keep more communication networks and channels open, as I said, via email or Moodle messaging, or of course, if possible, on the participants forum, so that more people can be involved and we can sort of share more experiences in this regard. I'll also be talking a lot more about my litigation experiences as far as industrial property is concerned. There will also be a bit of an overlap with competition law issues that arise, especially in the EU context. But again, I mean, this is, I understand, a 3 credit course. Yeah, it's graded 1, 2, 3, 4, 5, and there's only so much that one can do. But a lot of students have been taking up IP law as a master's course subject. So I really hope that will work out for you as well. Unfortunately, there has been this tendency of late to think that IP is stupid. Everything happens online, everything happens with software, and nobody cares about IP anymore. But it's also interesting to notice that some of the biggest patent applicants nowadays tend to be companies like Microsoft, Google, Facebook, Huawei, and then of course Samsung, and all of these companies. So it's very interesting to see how these things play out. Also, although a lot of focus is on digital services and the buzzwords that go with that, and then of course the implications for trademark law, copyright law are all apparent over there. It's also good to know that, well, in a crunch situation like coronavirus pandemic, it's going to be patent law that will decide whether you can be provided with cheaper vaccines at a faster rate or not. So, surprise, surprise. And of course, also it's interesting to note how many dreams and aspirations will get dashed over here. You do realize that Pfizer has a very good vaccine, but it has a lot of implications. It has to be stored at minus 50 degrees Celsius. It's expensive, I think about 15 euros or 18 euros a shot. And they were really hoping that they would make a ton of money with this. But a lot of cheaper vaccines have come out now. So although Pfizer may claim that they are 95% effective, you have cheaper alternatives, which are like, 1/5 the price. AstraZeneca, for example, and they don't have to be stored at very low temperatures. They can be stored in just -1 or -2, or rather, I think +2, +3 or something, not even minus. If it's minus, it gets spoiled. So you can already see how this can have an impact, because already it affects your transportation chains and things like that. So even though Pfizer may have got this perfect vaccine and may have got a patent for it, will they be able to commercialize it successfully? Well, yeah, that's a different issue. Patent law would teach you how to get a patent and some commercialization techniques and tactics, but again, there are no guarantees that after spending billions of euros in research, development, and innovation, you can still get your desired results as far as making money or profit is concerned. So enough of me babbling. Well, there's a 40-minute deadline over here somehow. So this is enough for today anyways. Next week we take up the lecture notes and the video lecture in more detail. And so until then, well, I hope you have a good time, and see you all next week then. Okay, goodbye.